Jeff. If you can just enable my screen sharing when you get a moment, I'd appreciate it. But in the interim, as Jeff mentioned, my name is
Done.
Schwartzseid. I am the managing partner of Kaye Rembaum's Orlando office. We have offices as well in Tampa, Palm Beach Gardens, and our primary office is in Pompano Beach, Florida, which is basically West Fort Lauderdale. So we operate, when you say statewide, yes, we may not have an office in Tallahassee, but I do have clients as far north as Perry and in various different areas. We truly represent communities throughout the entire state. If your community has any issues come up that you need counsel for, you need guidance, you need a second opinion, please feel free to reach out to me. We're happy to help. We have 20 attorneys, 7 of whom are board certified in community association law. 1 is board certified in construction law. Representing community associations is literally all our firm does. So if you are in a community association and you're not one of the owners seeking representation against the association, that's something that, it's basically what we've done since the 1990s. And representing community associations is pretty much all we do, as compared to a lot of firms that say they represent community associations, but it's maybe 5% of their business. It's really almost all of our business is doing that particular work. We'll occasionally help out owners who have a problem and need to recall the directors, but when it's a substantive issue, there are people that we usually recommend to handle that kind of work. So as Jeff mentioned, we've got a lot of material to cover today. I'm going to go ahead and get started. Thank you, Jeff, for enabling the screen share. My information is on the slides. As Jeff mentioned, you'll be able to get those slides after the class is over. Hopefully you can still see my face, and on that screen is my email address, which is also here. Email is the easiest way to reach me because I can see it wherever I'm at. Might not be able to respond immediately, but one of the important things that you should know about our firm, if you're not already a client, is that we do have a 1 business day turnaround time to at least acknowledge every communication that I get. I can't promise that if you're not a client that you'll get a substantive answer within 24 hours, within 1 business day, but 99.9% of the time, I'm at least writing back and saying, got your email, I'm working on it within 1 business day. I think that's a big distinguishing factor for our firm versus others. Okay, so enough of the spiel, moving on into the materials. Why the heck are we here today? Well, there's 2 options right now, and that might be about to change in the next few months. So one thing that I will clarify, I'm not going to go through a ton of the legislation that's pending right now. We'll have another legal update class to clarify what's changed, but until we see what actually passes by the governor's desk and is signed into Florida law, I don't think it's worthwhile with 188 slides to take time going through things that might be the law in a couple months. So look out for that legislative update class that my guess is I'll be teaching at some point in the next 2 to 3 months. Anyway, why are we here as of right now? Within 90 days after being elected or appointed to the board, a director has the legal obligation to either take a class like this and submit the certificate that you'll get after the class to the association so that it goes into the official records of the association, or they can sign a piece of paper that says, I've read and will do my best to uphold what's in the governing documents. That piece of paper, in my opinion, is pretty much meaningless because no one understands what's in your governing documents. They're almost always poorly written unless you've got an attorney like our firm that's worked already to try and amend them and make them actually make sense. So you're doing the right thing by being here. I hope that all of your directors will also come to a class like this instead of just signing that piece of paper that, from my perspective, not only doesn't mean anything, but frankly, is almost worse than nothing, because you're attesting to the fact that you've read the governing documents and you'll do your best to uphold them. I've actually seen that certificate come out in court where someone said that they had read the documents, but it was made very clear by the time that they were testifying in court that they hadn't read them, had no idea what they said, and were relying on advice of counsel every single time that an issue came up. Now, relying on advice of counsel is certainly a wise thing to do, but it's not ideal when you're looking at it from a perspective of credibility. You've basically lied by certifying that you read and understand the documents. So moving on, hopefully everyone that's here today will tell all of your fellow directors to attend a class just like this. Hopefully it'll be taught by our firm, but that's totally your prerogative. Moving forward. Okay, if you don't put that written certificate, whether it's the one you'll get today or another one that you signed and doesn't mean anything, into the official records of the association within those 90 days, understand that you are suspended from service until you complete that requirement. What that means is that you're not off the board, you're temporarily off the board. So the board can replace you until you complete that requirement, but the person that replaces you is going to jump right off the board and be forced off the board as soon as that requirement has been met, meaning that certificate is in the association's records. Now, just so that we're clear, the person you need to give these records to, this certificate, is going to be your manager if you're managed by a community association management firm or a manager, or your secretary if you don't have a manager. So just so you know what to do with the certificate after you get it, that's where it's going to go as part of the official records of the association. Now, this certificate needs to be maintained however long you stay on the board, but at a minimum 5 years after the director's election or appointment. So it's you get to keep this certification as of right now, unless the statute changes, for as long as you serve without interruption. Now, without interruption means you didn't come off the board. Suspensions are not counted there. So if you dropped off the board and then were appointed back on, if you had to resign temporarily and because of health issues or something, and then you were reappointed, you'll have to retake this class. If you stay on the board for 10 years, as of right now, the law does not require you to retake a class like this. It's my recommendation that you do it anyway because the law changes every single year. At a minimum, I would strongly recommend that you take a legal update class at least once a year so that you know what's going on and you're not relying on outdated information. If you've got these slides that we're going to give you today, but it's been 10 years from now and you're looking at this in 2034, I promise you most of what's in those slides probably won't be accurate anymore, even though it is today. Moving forward. Okay, Chapter 720. I need you to understand that there are a bunch of different statutes that your community association might fall under. So Chapter 720 of the Florida statutes is the one that talks about HOAs. If someone starts talking about Chapter 718, there's pretty much nothing in there that's going to pertain to your community. That is the condo statute. Okay, so moving on, we talk about some differences between an HOA and a condo. I'm not going to go through these. They're there for your information so that you understand some of these distinctions. But the biggest one is that an HOA is a creature of contract. Your declaration says most of what's going to go into your association. And that's important to note because some of the communities that you might be in, I represent a community that's 50 years old. There was no HOA statute when that community was created. It was just the declaration that got recorded in the county public records. So what's in that declaration will generally control. Okay?
And there's nothing wrong with 50 years old. I just want to throw that out there.
Good clarification, Jeff. Thanks. I'm not quite there yet, but I appreciate it. The HOA Act. So again, Chapter 720. What are the purposes? To give statutory recognition to HOAs. Provide procedures for HOAs that don't already have them in their bylaws, and protect the rights of the members. And this one's the funny one to me, without unduly impairing the ability of the association to perform its functions. I think the legislature has forgotten that this was supposed to be the purpose of 720 in some of the changes that they've made recently that we'll get into later. Now, keep in mind, 720 does not apply to commercial, industrial, or non-residential property. The commercial or industrial parcels, tracts, whatever you want to call them, in a 720 HOA, or any association, like I mentioned a minute ago, that's subject to 718 condos, 719, which is co-ops, or 721, which is generally mobile home parks. Actually, I think that's timeshares. No, that's 723, sorry. Except to the extent that a provision of that statute is directly incorporated into 720. So if 720 refers to a different statute, like I think some of the election disputes refer to 718, then you're going to look at that statute. Really, these are issues that your attorney should be giving advice on rather than the board trying to interpret the Florida statutes. But I do want to make sure that you're aware most of what you're going to look at is not going to be in 718, won't be in 719, won't be in 721. So if someone tries to tell you that the condo statute says you have to do this, your response is you're probably Googling that and you're probably getting it wrong. Anyway, another important factor to consider is which version of Chapter 720 applies. So which year's statute? And I won't go through this in depth because in reality, it's a legal analysis that your attorney should be going through. But I do want to make sure that you understand on these two slides, this one and the next one, that there is a big distinction. People just presume that if there's something in a statute, it controls over your governing documents because the statute is what the Florida state legislature has decided is more important. That's not necessarily the case, is the big takeaway that I want you to have from this slide and the next one. It depends what kind of change it is, and it depends what kind of language is in your governing documents as to whether the statute controls, whether your declaration controls, and if it is the statute, what year statute is the one that was the date that the declaration was recorded, or is it the one that's in place now as amended? Okay, the important language you're gonna want to look for in your declaration is this item 3 here, this Kaufman language, and that comes from a case, Kaufman versus Scheer, that included language in a condo declaration that talked about being the Florida statutes as amended from time to time were what was incorporated, rather than just the Florida statutes or just the Florida statutes as amended, because that as amended or just the Florida statutes could be considered to apply only the statute that was in place the year that the declaration was recorded. And the reason for that is that the substantive law that's in place as of the date of a contract is really considered under Florida law to be basically grafted into that contract. It's part of the contract. You're presuming that the laws that are in place right now are going to apply indefinitely unless the contract says otherwise. That's Kaufman language. So without getting into too much detail, I just wanted to be clear that you can't just presume the statute controls or the declaration controls or the bylaws control. It's going to be a legal analysis that your attorney should be doing to decide which of these controls. Now, if you've had that legal analysis performed before, you may be able to rely on that. But if it's never been done for your community as to a specific issue, you're going to want your lawyer to give an opinion. Part of the reason to get that legal opinion is that when you rely on legal opinions of counsel, as a director, you are protected generally from personal liability, even if the attorney got it wrong. So get that opinion, spend the extra money so that if someone tries to sue you personally, which we'll get into in a little bit, you're a volunteer. Do you really want to deal with an individual lawsuit where you're named as a defendant and not have the protection of having gotten advice of counsel? And I hate to put it this way, but having gotten that advice on the association's dime that everyone is paying for versus you having to defend that lawsuit. The better course of action is get the legal advice, be ready to move forward and say, we know we're doing the right thing. We're making an informed decision rather than these non-lawyers on the board or lawyers who don't practice in this particular area of law are making legal decisions as to what applies. Bad idea. Don't do it. Okay, moving forward. We kind of got into this, but you can take a look at this afterwards. And I know saying you can take a look at this afterwards when
Alan, let me stop you just for a second. I'm so sorry, but we're getting so many questions in the Q&A about whether this covers condominium. You're welcome to stay, but this is for homeowners associations. I know pay the HOA is a term loosely used in all association worlds for paying your monthly maintenance, but this is for actual homeowners association, community association board members. We'll have a condominium class next month. Sorry for the interruption, Alan.
No problem. Moving forward. So if you are here for condos, you're welcome to stick around, but you will not be getting a certificate that's going to help you. That will be available during my class next month. And it's towards the end of next month specifically. Okay, so conflicts between two chapters. I mentioned 720 that's going to apply to you guys. The other important one to know about is 617. That's the not-for-profit statute. Now, we do have some clients that are for-profit corporations. I'm not really sure why you would set an HOA up that way, but you're going to want to look at 607 if you're a for-profit corporation instead of a not-for-profit. But the bottom line that I want you to know about from this slide is if there's any conflict between what's required under 617 and 720, 720 will apply. So that's one, if you think there's a conflict, run it by your attorney. Don't just presume that you know which one is going to apply, because I've seen a lot of community associations get in trouble by making the presumption that there is a conflict when in reality there are two distinct requirements in the separate statutes. And the requirements of 617 still apply to the association, but they didn't follow it because they thought 720 required something different. So just be careful with that. Again, get advice from counsel at least once as to each one of these issues that might pop up. And then if you keep it organized as to what advice you've gotten, you can rely on that going forward unless the statute has changed. Okay, different kind of conflicts between the declaration, articles, and bylaws. So when there's a conflict within these documents, the important thing to remember is the old expression, a little dab will do ya. The order of importance and order of credence that a judge is going to give to these documents and the order of control in the event of a conflict is what's on the screen right now. Declaration is first. So let's go through what all of these are just so that you understand. Your declaration is your covenants, conditions, restrictions, your CC&Rs, however you refer to it. It's the constitution of your association. It's basically that contract that binds all the members, runs with the entire property, which should be described in the declaration, by the way. And anything that's in the declaration is essentially going to be presumed to be valid and enforceable unless it's arbitrarily enforced, or there are some provisions that will not be enforced. For example, race-related provisions. No Black people or Jews can live in our neighborhood. I promise you that's not one that's going to be enforced in this day and age. Okay, but 90% of what you might have in there is going to be enforceable. The articles of incorporation are the next document in that line of succession. That document's basically going to do very little more most of the time than state the name and purpose of the corporation. So it's going to say the name of the association is XYZ Homeowners Association Incorporated. The purpose of the corporation is to run a homeowners association for property located in Florida, in a particular county, in a particular city, blah, 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 blah. This may also say who the initial directors and officers of the association are, the official office of the association, etc. And then we get into the bylaws, which is going to be last in line of the official governing documents of the association. That's what most people think controls the day-to-day operation. That's really your declaration. What the bylaws control most of the time is your procedures. So how are your meetings run? What are the directors and officers' responsibilities? Things of that nature. How do you run your election? And then finally, it's not on this slide, but you've got your rules and regulations. Those are the things that the board gets to vote on without the members voting. Okay, they're going to be made by the board without member approval. And that's generally going to mean that they're scrutinized a lot more closely by the courts rather than just saying, oh, well, you know, we're going to go ahead and have the members vote. If you have the members vote, put it in the declaration. Now, these rules and regulations might include actual rules and regs that are basically in furtherance of and not in conflict with the declaration. They're going to be architectural criteria is one that I see very frequently. Something I recommend all community associations have, and I would suggest you take a note of this because it's not mentioned in the slides, are several policies governing the operation of the community. So you're going to want one for collection of unpaid assessments, one for enforcement of your covenants, we'll get into that later, one for how members are permitted to participate in meetings of the association and the board, records inspection requests, how are we going to deal with those? And then finally, how is the association through the board going to deal with requests for accommodations of the rules due to a disability? That's the Fair Housing Act, and in some instances, the Americans with Disabilities Act. Okay, those are the 5 that I think every single community association in Florida should have. I prepare them as a package where most clients that come and join us in Orlando have those prepared now, because frankly, I think they're so crucial to automate and facilitate the operation of your community. Once you have those 5 policies in place, the amount of attorney's fees you spend figuring out what to do in any given situation gets drastically reduced. So that's my recommendation for every community association. If your attorney isn't providing that service, doesn't know how to do it, or frankly isn't mentioning to you that you should have it, then you probably should be reaching out to me. And I do want to mention, we don't have any upfront expenses of working with the firm. There's no retainer, there's no annual fee, no monthly minimum, except for that we will pull and compile your governing documents. So usually, I actually have a lot of communities that will work on, excuse me, I should have had more coffee this morning, guys. I have a lot of communities that will come to work with us precisely and only to have their documents compiled and put together so that they are easily reviewed and OCR'd, so that they're searchable, and these policies prepared. And then I wait to hear back from the association if you need anything else. So just understand that is an option. I'm not trying to push it, but just understand we're here if you need us. Another thing that I will recommend is if your declaration includes those provisions that you don't want to enforce. For example, you don't want to go out onto someone's property and cure a violation because that's dangerous. You need to amend the declaration to take those out, not just choose not to enforce them. I have a lot of communities lately who want to just say, well, we don't like this provision, so we'll just ignore it. If it's in the declaration and you're ignoring it, that might be considered a breach of fiduciary duty, and I don't think that's something you want to do. Moving on. Members' rights and meetings. So we talked about member participation at meetings policy. Now we get into, well, okay, but what does the statute require? The bylaws are generally going to say when and where you hold and how you're going to call your annual meeting. That's your election usually. Okay. The other possible meeting are your special member meetings, which is basically every other meeting throughout the year that the members get to vote on something. That's going to be held whenever the board calls for one, or when you get a written request of at least 10% of the members, or whatever percentage is in your governing documents. Okay. Most communities, that's 10%. I have some where it needs to be 30%. It could be up to 50% if you really don't want to have the members have the ability to call that meeting. I don't know that that's really a helpful consideration, because in reality, you're supposed to be doing what a majority of the members want for your community, unless you think that doing that is going to be harmful to the community. And that's your fiduciary responsibility, is to do what's in the best interest of the association. The other thing, just understand that when you're sending notices for the annual meeting, it is the owner's obligation to notify the association of mailing and email addresses. So if they haven't provided you with a mailing address, or they haven't designated an email address, or they changed their email address and didn't tell you after they designate an email address, it's not the responsibility of the association to make sure they receive the notice. Now, that may not be helpful to you. It's helpful to say, if an owner tries to challenge the validity of the notice, well, you know, we sent it to the address that you gave us, or you didn't give us an address, so we sent it to the property. What that doesn't help with is to ensure that you actually get a quorum if you're trying to pass amendments. Electronic voting is another thing that I think most community associations should be considering, but we'll talk about that later. Moving on, notices and agendas. Just understand every meeting of the association or of the board must be subject to an agenda. That law changed last year. I always thought it was a good idea. Now it is absolutely mandatory under Florida law that for every meeting that pertains to the association, that requires notice, which not all of them do. Some committee meetings don't require a notice, but any meeting that requires a notice also must have an agenda. Okay. If you're trying to do one of two things, you'll need a 14-day notice. One is the annual meeting. Another is if you're trying to pass a special assessment, or any assessment really, you need to give 14 days notice before that meeting. Usually a board meeting would only require 48 hours notice. Okay, we'll go through that in a little bit. But the notice needs to say how to attend the meeting. It needs to include the date, time, and location. And you need to actually send it to the addresses that the owners have given, not just, well, we're going to send everything to the property addresses. If you know that the owner's not there and they've actually given you an address, not you know the owner's not there and that's it, but they've actually given you a different place to send those notices, you have to follow that request. You can adopt a procedure for conspicuously posting and repeatedly broadcasting the notice on CCTV. That's basically going to be like the HOA channel. If you've got that special capacity set up in your community, again, that'll be one that you want to run by your attorney. We talked about notices need to include an agenda, so we don't need to go through that. Keep in mind, if you are trying to send notice electronically of pretty much anything in your community, you're going to need to make sure that each of the members that's receiving that notice actually agreed to accept electronic notices. Any member who didn't agree to that, you still need to either post the meeting notice or mail it to them. And you might need to mail it even if you're posting it, depending on what type of meeting you're talking about. So keep in mind also, a special meeting notice needs to specify what the purpose of the meeting is. If it's just a board meeting, probably not an issue, but if it's a special meeting of the members, they are entitled to know what the meeting is about so that they can make a decision as to what they're actually going to be, deciding on at the meeting. And if they care enough, they can show up. Let's see. Moving along. The members do have the right to participate in every single meeting, whether it's a board meeting or a member meeting. They don't have the right to vote at board meetings, but they have the right to attend. They have the right to speak for at least 3 minutes on each agenda item. Now, again, this is one of the policies that I'm recommending every community association in Florida should have, so that you can restrict the time that they're allowed to speak on each agenda item to 3 minutes. You can't restrict it for a shorter time frame. You can't say you get 30 seconds to speak. You can only restrict it to a minimum of 3 minutes. And if you don't have those written rules in place, keep in mind, part of the problem is, we don't have a problem now with people that want to speak forever or, basically hold up our meetings. As soon as you have that person, they're going to try and argue that you're going after them personally if you start to adopt this policy after the fact. Doesn't mean you can't do it anyway. But as soon as you've got the person that wants to speak for 15 minutes at your meeting and is having everyone cede their time to this person so that they can be the spokesman or spokeswoman, whatever, as soon as that starts to happen, your meeting is going to deteriorate and you're not going to be able to get your business done. Or you're going to have to sit there for 3 hours instead of a 1-hour meeting. So my strong recommendation to every community association in Florida, get a member speech at meetings policy in place so that everyone knows if you want to speak, you sign up in advance. Everyone knows when they'll be permitted to speak, whether that's before, during, or after the consideration of board motions and what's on the agenda, and they'll know for how long they can speak. Keep in mind, the members also have the ability and legal right to record every meeting. That doesn't mean, and this is an issue that I've had come up, that doesn't mean they can post the video on Facebook. It doesn't mean they can share it with anyone that's not a member of the community. It means they're allowed to record it and, if necessary, re-review it or present it in court. Doesn't mean you can send it, post it on YouTube. That is something I've had come up in the past, so I just wanted to be clear. The other thing to keep in mind, there are 2 reasons that you can say, well, this meeting is closed to the members, even though it's a board meeting, that they would otherwise be able to attend. One is if you're having a closed legal meeting with counsel, okay, meaning there is potential or ongoing litigation, not we're working on amendments, okay, that is not a closed meeting. That's an open meeting where you're discussing with counsel. The other possibility is discussing employee matters. That doesn't mean management company employees, by the way. It means people the association is directly hiring. Now, keep in mind also that even if you're able to close that meeting, the salaries, the information that results from that closed meeting is still most likely going to be subject to inspection in the official records of the association. It's a different story when it comes to the privileged meetings with counsel, because presumably that potential litigation would still be ongoing after the meeting. So your minutes of that meeting are going to be very sparse. The other thing about meeting minutes after you have your meeting, I want to be clear, that is not a verbatim recitation of everything that was discussed during the meeting. It's not John said this, Jim said this, Jane made a motion, Jack, apparently I'm stuck on Jay today. Jack seconded the motion. We had 20 minutes of discussion, and here's an entire paragraph and a half of what was discussed and who said what. No, it's here's what was on the agenda. Here's the motion that was made. Here's who made it and who seconded it. Here's how each director voted or abstained. Here's how the outcome was. Okay, that's all that goes into the minutes. The text of the motion and the vote, and who made it and who seconded. Abstention, meaning you choosing not to vote, should only happen if you have a conflict of interest. Not a manufactured conflict because you don't want to vote, but an actual conflict. If you don't vote, you end up dealing with whatever the result was. Okay, it's not a vote no, it's not a vote yes. So if you don't like what the board's doing, vote no. If you like what the board's doing, but you're not comfortable voting yes, perhaps you shouldn't be on the board because you're incapable of making these important decisions for your community. Okay, moving along. Quorum and decisions. Unless a lower number is provided in the bylaws, your quorum is 30%. A quorum is basically the number of members that need to actually attend your meeting in order to have a meeting. If you don't get a quorum, you can't have a meeting because there weren't enough people there to actually have a vote of the association. Member decisions are generally going to require a majority of votes during a meeting at which a quorum is present. What does that mean? If you've got 100 members, 30% is your quorum. You need 30 to show up and 16 to vote in order to pass a motion. Okay, so that's the simple-ish math. Now, keep in mind, your governing documents may say otherwise. If you need a 50% quorum, the first thing I want you to do is have your attorney prepare a proposed amendment to reduce the quorum amount. And if you have a supermajority that needs to vote, you might want to have a reduction of how the votes happen. For example, if your amendment provision in your governing document says to be amended, this governing documents requires a 75% vote. Amend that, change it, make it easier to change what's in the documents. Now, don't make it so simple that you only need 2 people to show up in a 100-member community, but make it so that 20 to 30 people, and you would be lucky to get that to show up in a 100-member community, can actually accomplish something if the members want a change. Moving forward, proxies. Keep in mind, the reason that I invalidate or clients ask me about it and I say, nope, not valid as to proxies, the biggest reason is that it's not dated, doesn't have the actual property address of the person, or doesn't identify whose proxy it is, issues like that. So here's just a quick list of what the proxy needs to include. The important part here is not only that it includes this information, but almost more importantly, that it's only valid for 90 days. So if you have a meeting, no quorum is there, so you have to continue it and try again later. And that reiteration, that continued meeting is more than 90 days after the initial date that the proxy was given for. So let's say my meeting was in April and the new meeting that is continued because there was no quorum is in August. That's more than 90 days later. That proxy is no longer valid, even though it's the same issue being voted upon. So just understand those proxies are only good for 90 days after the date of the initially scheduled meeting. They can be revoked at any time by the person who signed. In other words, I can show up at the meeting even though I gave someone my proxy and vote on my own. The proxy holder can appoint someone else as a substitute proxy to act in their place if the original proxy says that that's allowed. And a copy of the original proxy can be used if it's a complete reproduction of an entire proxy. I see this come up too. It's only the bottom half of the proxy. Sorry, but that's not good enough for me. Okay, moving on. General versus limited proxies. Both limited and general can be used to establish a quorum. Again, that's the amount of people that need to be present. You can be present via proxy at a meeting. So if you hand someone your proxy and they collect 30 of them, I don't care if you're physically there or not. 30 people showed up to that meeting, plus the proxy holder, which presumably would make you 31. Okay, a general proxy basically says vote however you want at a specific meeting. It's not vote however you want indefinitely. That's a power of attorney, and it may or may not be valid for purposes of HOA voting. A limited proxy says, here's how I want you to vote on my behalf. Pretty simple. Okay, flag laws. This is basically a covenant enforcement issue. You know, when you've got your flag restrictions in your governing documents, Florida law says that those don't matter. Okay, this is what I was talking about earlier, that it's not supposed to be a big imposition on HOAs. This flag law basically says, I couldn't care less what your governing documents say, what your rules and regulations say. You cannot tell an owner that they can't display, pardon me, up to 2 of the following flags in a respectful manner. We go through the U.S., this Florida flag, any military flag of the U.S., a POW MIA flag, or a first responder flag. You can also fly 1 U.S. flag and 1 flag from this list from a freestanding flagpole. Now, there are size restrictions that are in the statute. We don't go through them here, but just understand you can't tell someone they can't fly these flags. Now, the question that I got during my legal update during this week's Condo and HOA Expo, what about an American flag that's been dyed black? Well, that's going to be up to a judge as to whether it still qualifies as an American flag after it's been dyed. You talk about the veteran, and I've had the question come up also. It says veterans for Trump, veterans for Biden. Is that a veterans flag? Is that a military flag? Or is that a political flag? My answer is, I don't care. The fact that it says veterans doesn't mean that it falls within these military flags. There is a specific flag for each of these branches of the U.S. military. If it's not one of them, sorry, but I don't have to allow it to fly in the communities I represent, and neither do they. So just understand there's always going to be someone trying to skirt these laws and use them to their advantage. You might want to get guidance of counsel as to what you still can and can't enforce regardless of your governing documents, which is why we say, I don't know whether the statute controls or not. Until you go through the analysis, or more accurately have your attorney go through that analysis, you shouldn't just be presuming that because your governing documents say something, that's the law. Similarly, this is another terrible law that came out last year, the installation, display, and storage of items. It doesn't matter what's in your governing documents. Anyone can display, store, or install pretty much anything they want, as long as it's not visible from the frontage of the lot, meaning in front of the residence, or from any adjacent lot. Now, there are changes to this that are hopefully coming down the pike this year. Again, we'll probably have a legal update in the next few months between Rembaum's roundup and I'm guessing another webinar that'll be explaining all of these changes. But the bottom line is this, in my opinion, is a completely unconstitutional law. The problem with that is that do you really want to go through the exercise of spending hundreds of thousands of dollars to have the Florida Supreme Court decide whether this is constitutional or not? I don't know of any community association that wants to spend that in order to get someone to remove the pavers from their backyard. I just haven't seen it. Now, the other thing, I mentioned the pavers in the backyard. This doesn't say that if a violation is created as a result of the installation, display, and storage of items, that's not an enforceable violation. So the paver example I gave, if someone installs a bunch of pavers in their backyard, kills all the grass, so they no longer have a backyard, it's just a back patio, basically. And because there is no grass and really the soil isn't accessible and everything is blocked off with the pavers, you get flooding in an adjacent lot, you get flooding on common areas. That flooding is still an enforceable violation. So the result of all these things is still something the association can enforce. It's just the display, storage, and installation that the association might not have the ability to enforce. The other thing I'll point out here is that this is not something that the association must affirmatively do. It's an affirmative defense to an enforcement effort by the association. Now, that doesn't mean you won't get sued over it, but just understand the owner has to be wise enough to bring this up in order for it to matter. A couple things that aren't mentioned in the slide, so I'll mention them here because they're relevant to this installation, display, and storage issue. The over-the-air device rule. It's OTARD. It's a federal law, but it's basically when you have a satellite dish or something similar on your property, the association has to actually allow that. So you can't say someone can't have a satellite dish. You can say where it needs to be located. You can say that it can be located in an area that is not visible, unless that location is going to stop that satellite dish or antenna from actually working properly. Same thing with energy saving devices. That's where we get into solar panels. You get into, what is it? The wash lines. I can't think of the name of it right now, but you get into anything that is considered an energy saving device. You can tell people where they have to put it. You can't tell them they can't have it, and you can't tell them they have to put it in a place that won't actually function. So if the sun doesn't reach this side of the house, you can't require someone to put their solar panels on that side of the roof.
You're referring to a clothesline?
Clothesline, thank you. Someone needs to clothesline me right now so I can wake up. Thank you.
Coffee.
Yeah, I ran out, and I'm going to keep moving rather than go get some more. Florida-friendly landscaping is something that I don't know many landscapers that fully understand it. But the bottom line is that's something that you have to allow. And then we've got, like I said, your disability response policy for people that request accommodations. If someone has a disability and saying that they don't have to follow a certain rule will serve that disability, the association is going to be required to allow that violation. And it's technically not a violation. It's an accommodation of the rule to allow that person the same use of your facilities. So for example, if someone needs to have an emotional support animal, but you have a no pet policy, sorry, but that's no longer a pet once it is qualified as an emotional support animal. A service animal, same thing. If that service animal serves a specific purpose to create an ability of that disabled person to use their property the same as everyone else would that doesn't suffer that disability, you're going to have to allow it. So just understand before you try and enforce all of these things, make sure that you've gotten an opinion from your attorney as to whether you're allowed to enforce it. Okay, moving forward, the members have the right to know what architectural standards are actually going to apply when they submit an application to your architectural review committee or board or whatever it is in your community. It's called a bunch of different things. It might be an architectural review committee, architectural review board, architectural control committee or board, etc. Whatever it's called in your community, they should be establishing criteria that specify the size, location, setbacks, all of that stuff, the color wheel that you're allowed to use, everything that goes into what you're allowed to install on your property. Okay. If that is not set forth in either the declaration or separate criteria, you generally can't tell someone that they can't do something on their property. So what I would suggest is some attorneys, including me, have kind of like a form criteria. Most of it won't apply to your community, but you can use that and take out the provisions that you don't want in there, change the ones that you do, and then have your attorney review to make sure that you are actually including things that are enforceable under your declaration, because this is the equivalent of a rule of the association. Yes, it's adopted by the board, but it still can't conflict with what's in the declaration, and it needs to be to some extent supported by the declaration. The other thing to note when it comes to these types of rules and regulations regarding use of a piece of property, a lot within your community, that's going to be a 14-day notice before the board meeting where the board is deciding on what goes into those. Okay, moving on. If an association gets a deposit, this is usually going to be either from tenants or regarding construction. This law recently changed. The association can't commingle those funds with any other association funds. Once the project's completed, the deposit needs to be returned to the members within 30 days after the association is notified that the construction project or whatever other reason the deposit was collected for is done. Meaning if that tenant moves out and the owner actually notifies you, you need to send that money back. You also need to give an accounting for what was done with the funds while they were not commingled with other association money within 7 days after receiving a request for that. Now, the other thing I'll point out that isn't in the slides, based on my experience, is make sure that whatever provision of your governing documents or your rules actually requires that these people deposit the funds with the association also says who gets it back. The slide says the members. Great. But that doesn't mean there's a statute that says the member gets it back. It doesn't mean that your rules say the member gets it back. And you don't want that contractor or that tenant or whoever it may be to start arguing that they're entitled to the money and threaten to sue you. And then you've also got the owner threatening that lawsuit, because then you end up giving the funds to a judge or to the court system more accurately, so that the judge can decide who gets the money. And then you've paid a bunch of attorney's fees to file what's called an interpleader lawsuit so that that judge can make the decision and you can have the association dismissed. That can be avoided by literally saying in your rules and regulations or wherever you're talking about this deposit, the association will return the funds to the member upon conclusion of the project or conclusion of the lease. Just a little pro tip for you guys. Members do have the right to inspect and copy all official records of the association, although there are exceptions and exemptions stated in the Florida statutes. Now, there are certain changes that might be coming down the pike. They haven't kicked in yet, and the bills haven't been adopted yet, so we're not going to go through them here, but just know this is one that might change in the next few months. But generally speaking, you need to keep all documents pertaining to the operation of the association in the official records. That's the easiest way I can explain this. Now, even if there's an exemption that says the owners don't have the right to inspect certain records, that doesn't mean that they're not official records or that the association doesn't have to maintain them in whatever location and whatever medium that you keep these records in. It could be digital, it could be physical, it could be keeping it in 40 different boxes. I couldn't care less how you maintain it as long as you maintain it. The email address that members give for official notices is part of the official records, but anything that's given, I've seen this come up, anything that's given just for the purpose of email blasts that aren't official notices, even though they're coming from the association, they're more informative than official. That's not an email that's been given for purposes of email notices. I literally had that come up about 2 months ago, where an owner was claiming that they're entitled to inspect all of the email addresses the association has for every member. Only the email addresses that are given for purposes of notices are subject to inspection by the members. Same thing with fax numbers for that purpose, mailing addresses for that purpose. If someone says, I don't want you using this email, fax number, mailing address, that information needs to come out of the official records. So we're not going to go through what this is, because look at the last bullet point. All other written records of the association not specifically identified in the statutes, which are related to the operation of the association. That's a catch-all. It's everything. Okay, so we won't go through every little detail of this, but just understand, unless the statute says otherwise, all official records need to be maintained for at least 7 years. Another policy that I don't think every community must have, because a lot of communities just keep their records forever, but excuse me, if you intend to eliminate, destroy, get rid of those records at any time, including after that 7 years is up, that needs to be pursuant to a written policy of the association. It needs to say how you maintain the records, how you're going to destroy them, when you're going to destroy them, what you're going to do to safeguard to make sure that those records don't get into the wrong hands. Once they're destroyed, basically shred it and send it. Or if you're only maintaining digital files, delete it and it's gone. The other thing that I do want to mention is the ledger for each property in your community is subject to inspection pursuant to a records inspection request. What that means is not you give out the ledgers every month to tell everyone who's delinquent. What it means is if someone says, I want to see my ledger, or I want to see my neighbor's ledger, you do have to respond to that inspection request and provide access to those ledgers. That will not violate fair debt laws. Okay, but if you just give the ledgers out to everyone, that's a violation. So understand, you have to allow the inspection. You're not going to give them away just willy-nilly, so to speak. All right, effective July 1st, 2021, the official records also include the ballots that are kept for 1 year. All of the election records need to be kept for at least 1 year after the date of the vote, meeting, election, whatever it may be. And then all affirmative acknowledges made that the association is going to change The way of notifying the members how they pay their assessments also are now official records of the association. Now, I mentioned that there are a bunch of records that the members don't get to see. They're not subject to inspection. Let's go through those really briefly. That I think is important. Attorney-client or work product privileged information. Some people will say that that privilege only extends until the proceedings, the lawsuit, the arbitration, whatever is completed. I totally disagree with that because that can be reopened at any time, or unless there is a final adjudication, another lawsuit that pertains to the same issues can be raised. So I don't see how that is subject to the attorney-client privilege being given up unless the board actively makes the decision to waive privilege. Another issue I've had come up in the last few weeks, no individual director gets to decide to waive attorney-client privilege and talk about privileged discussions with counsel with someone who's not on the board, not a manager of the association, and not the attorney. So you don't get to go tell your members everything that was discussed or anything that was discussed that is privileged during an attorney-client meeting, period. Okay, only if the entire board has voted, not that it's a 100% vote, but that at least that majority of a quorum has voted to decide that that issue is going to be disclosed to the members. You're not going to disclose it to someone who's not a member. Okay. Other information that you can't get as a member. Information regarding the sale, lease, or transfer of ownership of a property, medical records of the owners, personnel records, association passwords and software. You don't want people to be able to manipulate the data that you're using as your record. So you produce a PDF or give them a printout of a QuickBooks data. You don't give them access to the computer it's on or send them your login for QuickBooks Online. Personal information of the owners, which those owners can choose to discuss. And then good news, if you disclose this information that you weren't supposed to give out, there's no harm, no foul, as long as it was inadvertent. Okay. Moving on. We talked about all this, talked about attorney-client privilege. Your membership directory is subject to inspection, period. So don't think that the contact information for your members can be kept just because you think that someone's going to use it to try and badmouth the board. I hate to be blunt, but that's going to happen in a lot of communities. You do have to provide that information. You have to provide your roster to the members. The statute also says the association shall maintain an adequate number of copies of the recorded governing documents to ensure availability. I don't think anyone can tell you what an adequate number of copies is. My perspective is if you've got a website, put it up on the website. It's already in the public record, so who cares who accesses it, and let them access it that way. The amount of storage space that you're going to need in order to do that, instead of having 20 copies of 100 pages worth of documents sitting in the office, it's worth it to just put it online. Now, the important part for the association is not just maintaining these records, but as I mentioned, you have to actually allow the members to inspect them and copy them. You have 10 business days from receipt of a request to inspect those records, to allow the members to inspect and copy them. And there is a rebuttable presumption that you intentionally didn't give up the records if you don't provide the records within those 10 business days. Now, I mentioned this is a rebuttable presumption. What that means is the judge in any lawsuit talking about this case is going to presume that the association intentionally didn't give up the records. It then, instead of being the owner's obligation to prove that the association did that intentionally, becomes the association's obligation to prove that it wasn't intentional. How do you prove that? Well, give proof that there was a flood in the records room, that there was a hurricane going on during the records inspection request. Okay, fortunately, I no longer need to talk about, well, it was COVID. But the bottom line is you need to know that you have a basis to rebut this. Sometimes you will have issues if you shift management firms with the prior manager not giving you the records. Whether or not that's a sufficient excuse will probably depend on how hard you tried to get those records from the prior management firm, if not having them is the reason that you weren't able to produce them. Okay, keep in mind, if you don't produce these records within the 10 business days, there is a $50 penalty that you owe to the owner, not the government, for every day that you do not produce the records up to 10 days. What that means is you're giving them a $500 gift by not producing the records. Now, I've had some communities decide it's worth it to spend that $500 to get everything in line and make sure that you are taking out everything that needs to be redacted from those records. That's your prerogative as a board. It's not something I'd recommend. If the records are maintained online, you may also need to provide a computer so that the owners can access them. Because I've heard a lot of people say, I only have a tablet. I mean, I have an iPad. I also have a computer. Not everyone does at this point. And you should be able to access all this stuff on a tablet, but some websites just aren't set up for that. So just be careful as to how you're going to do this. One thing I want to mention is the last thing here, cherry picking records, meaning you're combing through the association records and pulling out the specific ones the owner asked for in the request that they sent to you, is not something the association has to do. If you have 40 boxes worth of crap that are lying around in storage somewhere, you pull those 40 boxes out of storage and say, here's your records, have the inspection. Now you're going to keep someone that is association related in that room so that no one's taking anything out of the boxes and taking it with them or marking it up and you know, basically destroying the records. But you don't have the legal obligation to go out and find the specific documents that an owner is looking for. That's something that might change in condos this year. It's not something that I think is getting ready to change in HOAs. So you're probably still safe for now. Again, you can have a policy governing how these records inspections work, where they need to be sent, whether it's via email or certified mail, whatever. The only things you can't do is require an owner to show a proper purpose for the inspection. They have a right as a member to go in and take a look at the records. State a reason for the inspection. Again, you can't tell them you can't inspect the records unless you tell me why you want them. It is, I requested to review the records and I'm a member. That's all I'm required to show association for me to be able to do this. And you also can't limit the right to inspect the records to less than 1 8-hour business day per month. Now, part of the reason that I recommend having this policy in place is to limit how the members can request, because otherwise I have been in communities or represented communities more accurately that got a new request from a certain member every 3 to 4 days. You can say you can't submit more than one of these within a month, okay? The other thing you can do is say you cannot submit it more than once within 30 days, because otherwise you'll get one on the 30th and another one on the 1st. Okay, so these are things that attorneys that work in this particular area of law will know about, hopefully, and if not, then you're working with the wrong one. But bottom line, you can adopt a policy and frankly should adopt a policy governing how this works and how this records inspection is going to take place, when, where, etc. Now, the fees associated with management can be charged depending on how many copies you need. If it's in excess of, I think it's a half hour that management spends compiling the records, or if it's 25 pages or more, you can charge for copies of records. You can also allow them, or you must also allow the person that's requesting these records to use a portable device, meaning their phone, their tablet, a camera, to make copies of the records themselves. Okay, so you can't tell them you can't take a picture of that, you have to pay me for copies. Doesn't work that way. Okay. Now you can also say, well, we don't have a copy machine here in the office. We're going to have to take them to Kinko's and you'll get your copies once you pay for the actual cost we're spending at Kinko's, if it's more than 25 pages. So just understand, you know, some of these limitations, you should be putting them in your records inspection policy directly, so everyone knows what to expect when they're coming in to do this inspection. The other thing I want to be clear on that I don't think is mentioned in the slides, let me check the next one. Nope, we went through this. We went through this. And that's it. So let me explain very briefly before we go into elections. The association is not obligated to coordinate a time and date that works for the owner. The association can write back to the records inspection request and say, this is the time, date, and location where we will make ourselves available for the inspection you've requested. And then if the owner responds and says, I can't make it on that date, your response is, okay, here's, maybe you give them one more date and time and location. And if they can't make it, your response is, okay, well, you can submit another request next month. Have a nice day. You don't have to make your best efforts to accommodate an owner that's making a records inspection request. Okay, moving on, elections. This is one of the easiest and most difficult parts of dealing with an HOA. The reason for that is that it's super easy to explain how to do an election properly because the statutes are pretty bare bones. It's not like the condo procedure that is 100% clear under the Condominium Act and Florida Administrative Code. Whereas in an HOA, it's basically, okay, well, here's how you do your election. Look at what the bylaws tell you to do and do it. Well, a lot of bylaws are really poorly worded. So that's the problem, but it's actually really simple to do an election properly. You just follow what the bylaws say, and if the bylaws are unclear, you try and amend them to make them clear. The other thing I want to point out, just a couple pro tips, okay? You want to avoid disputes over the validity of the election result. One way to start doing that is to make sure before you eliminate nominations at the meeting, make sure the documents don't say you can nominate yourself from the floor. Make sure that if you are telling people they can't be on the board, that you've got the proper documentation to show that they are delinquent, or that one of the things that we'll get into as to you're not an eligible candidate is accurate. Make sure that people are not voting more than once, even though they only have one vote. Before you eliminate those votes, you'll want to refer to your counsel. You might want to have a walkthrough if you don't have your attorney actually at the election meeting, so that they can let you know what the reasons are that you would be entitled to tell someone, sorry, but your vote doesn't count. Similarly, voting restrictions, basically suspending the right to vote. One, it needs to be in your governing documents for you to do it in the first place. But two, it requires actual notice. It's not just you're 90 days delinquent. You didn't pay over the last 3 months, so you don't get to vote. It's we actually went through a board meeting and notified the owner in advance of the election that they will have their right to vote suspended. The other final pro tip before we get into the materials here, make sure to formally close the balloting at some point during the process. That can be, pardon me, 20 minutes into your election. It could be 5 minutes in, it could be an hour in. But before you start counting those ballots, close the balloting so that you can stop people from submitting more ballots while you're trying to count the ones that have already been submitted. Because the proper way to go through it, depending on how your balloting process works, might entail opening a bunch of envelopes, and you don't want to be doing different stages for different people that are counting the ballots. That might be a little confusing to someone who hasn't done an election before, but anyone that's done a condo election knows you're going to open an outer envelope and an inner envelope and then count the ballots. It's a whole procedure that fortunately most HOAs don't need to work with. If you want to make your election procedure clear and simple, one way I have done that for some communities in the past is basically copy and paste the condo procedure into your bylaws as an amendment. Moving forward, the election, basically you need a quorum unless your bylaws say you don't in order to hold an election. If you don't hold an election, that doesn't mean you don't have a board. It doesn't mean that anything that the board does during the subsequent year is wrong. It doesn't mean you must hold another election meeting in order to try and get the quorum. It means that your board holds over for one more year, possibly one more term, depending on your bylaws. Okay, keep in mind, if you're in an HOA, you got to give 14 days notice before the election meeting, unless the bylaws say otherwise. You might need more notice than that. I would suggest not giving any less notice than 14 days before your election is going to take place. Now, generally, anyone that wants to serve on the board can volunteer. However, if you were convicted of a felony and have not had your civil rights restored at least 5 years prior, meaning you came out of prison at least 5 years ago, you're not eligible to serve on the board. If you have pending criminal charges for felony theft or embezzlement involving association funds or property, I think it makes sense that you can't be elected to the board. And that's a guilty until proven innocent, by the way. Okay. Unless the bylaws say otherwise, you're going to serve a 1-year term. The decision of who ends up on the board is whoever gets the most votes. Pretty straightforward. Vacancies caused by the expiration of a term are filled by an election. If someone resigns, dies, or is pulled off the board, That is generally filled by appointment by the other directors, meaning the board votes on who is going to take the place of this person that's now off the board, or you can go with a new election. From my perspective, a board meeting is almost always going to be easier than trying to get a quorum of the members together. Go with the appointment if you have that option. Okay, let's see. Election records are official records. So make sure that you maintain all of the envelopes, all the ballots, all the proxies, etc. Any challenge to the election process. Now, that's not a recall, but questioning the procedure of the election itself must be raised within 60 days after the election result is announced. Candidates are anyone who submitted their timely written notice of the intent to run. That's going to be what's in your bylaws. It might be at the meeting that you can state your notice of intent. It may be sometime before then. In a condo, it's no later than 40 days before the meeting. So if you've adopted that timeline, you might have that requirement to put your name in the hat in advance of the meeting. If it's not in your bylaws, it's not required. Let's see, election challenges. We talked about needing to bring that 60 days after or after the election result is announced. Keep in mind, I mentioned recalls. Those won't be considered by anyone, a court or the DBPR, within 60 days before or after an election. If you're before the election, you got to wait and see what happens in 60 days. If you just had the election, you got to challenge the election process or wait 60 days after the election to go forward with your recall. And the reason for that is all that recall lawsuit or arbitration petition would do is waste an arbitrator's time, because that's going to be changed. The composition of the board could change as a result of that election anyway. I talked about electronic voting. I think it's something that a lot of communities are not looking into, but should. Some of the vendors that are out there will not require you to actually even pay more than you're paying to mail out the notices in order to use their services. And you do tend to get a much larger vote than you normally would, because a quorum's much easier to attain when someone can go on their cell phone and vote on association issues versus going out of their way to physically attend a meeting, or frankly, even to mail their proxy to someone or mail the proxy to the association. I see people that are frankly so lazy that they won't even mail that back, but they'd be willing to sign a piece of paper. And now it's actually going to be, you can electronically sign. So you can just fill out a form on the association website to sign in for electronic voting and opt in. The only caveat there is that you need to have at least 14 days prior to the meeting. You need to have a written resolution of the board adopted. That's something we prepare for our clients. Most of the vendors won't prepare that resolution, but they will prepare some of the opt-in, opt-out forms, etc. But we just prepare it as a package and make it easy for the association to have that information available. And if that is adopted by the board at least 14 days in advance, then the people that opt into electronic voting are able to vote that way. There are certain things that are required. Your vendor should be providing all this, and you should work with your attorney to figure out which vendors are capable of making sure that these legal requirements are met by the electronic voting vendor. Officers are different from directors. So let's take a step back and talk about several of the terms that I've been using today. Okay, you've got your members. Those are the owners of property in your community. You've got your directors. That's the board, the people that we just talked about being elected by the members. Finally, you've got your officers. Those are the people that have specific positions. Your president, VP, treasurer, secretary. Okay, they have specific responsibilities. Those people are going to be decided by the board. So the members don't elect officers. The other thing I want to be clear on, I hear it used constantly and it's wrong. Okay, the president of the board doesn't exist. The board doesn't have a president. The board has directors. What do directors do? They make motions, second motions, discuss motions, vote on motions, or abstain. That's all a director does. Officers don't get to vote. So if you've got people who are officers but not directors, they don't get to vote at board meetings. They get to vote as a member if they're a member, but they don't get to vote at board meetings unless they're also a director. So I want to be clear about that distinction between the three hats you might have. So here where it asks, does the president vote? The answer is no, the president doesn't vote as president. If the president is also a director, the president gets to vote as a director at board meetings. Members do not vote at board meetings. Members do not have a quorum requirement at board meetings. A quorum of the board is all that needs to attend. So if you've got a 5-member board and only 3 people attend that meeting, but they happen to be 3 of the directors, you've still got a quorum to have that board meeting. If that was a member meeting, then you wouldn't probably have a quorum of all of your members unless your community is also a 5-member community. Now, moving forward, directors can't vote by proxy or secret ballot at board meetings, except in electing the officers. This is a transparency issue. You want the members of the board, the directors, to be announcing the way that they're voting so that everyone sees it, everyone hears it, etc., and it's reflected accurately in the minutes. Okay, we've got changes that took effect October of last year. A bunch of fraudulent voting activities. Basically, don't bully anyone into voting. Don't pay them to vote in a certain way. Don't threaten them with violence or anything else if they don't vote a certain way. This is actually a misdemeanor of the first degree to use bribery to directly or indirectly influence someone as to how they should vote. Okay. The board, we talked about a little bit of the hats that the board wears. One of the things that I mentioned but haven't explained in detail, and I think it's really important that everyone that's on the board understand, is the fiduciary responsibility that each member of the board has toward the community. A fiduciary duty is owed by every member of the board, and it's essentially the same duty that a trustee has to a trust. It's the highest duty imposed by Florida law. It says you must do what is in the best interest of the association, even if it hurts you. Now, the good news is this is the highest duty imposed by law, but it's judged by the dumbest person in the room standard. All you need to show in order to show that you complied with that duty is that you weren't arbitrary or capricious, meaning you weren't doing something to make an emotional decision and be a jerk, but you're deciding in what you reasonably believe to be in the best interest of the association when you made your vote. Now, one of the most important bills that you will pay as a community association is your directors and officers liability insurance policy premiums. Okay, what's the directors and officers liability insurance policy? It's essentially an insurance policy that says if the individuals that are on the board or that are serving as officers get sued in their individual capacities for doing something pertaining to association business, they're going to be covered by this insurance policy. This is separate from the indemnity that the association governing documents will generally include, where the association is going to cover the expense of defending those individuals or pay out any damages awarded against those individuals. So just understand you can't completely screw around as a director and think you're going to get away with it. But for the most part, if you've got this policy in place, this directors and officers liability policy, if you've got your indemnity in your governing documents, chances are you're covered unless you really screwed up. Okay, the great power grab. Understand that most of the things that the association is going to be voting on, the board of directors gets to control. Okay, so the members will rarely vote for anything in an HOA other than to adopt reserves or to amend the governing documents or make changes to the community. And when I say make changes to the community, what I don't mean is material alterations where you're changing the landscaping. Okay, what I'm talking about is major shifts in the community itself. The board's generally responsible for the maintenance and operation of the association unless the members get to vote. So 90+% of everything the association does, your board gets to decide. So if the members are upset that the members don't get to vote on an issue, then it's their responsibility to either put out an amendment that says the members get to vote on it or shut up and let the board do its job. Those are the options. I hate to be blunt like that, but that's reality. The board was elected or appointed to do the job of making sure this community runs properly. If you don't think that the directors are doing that, you can try and recall them, meaning remove them from the board regardless of wrongdoing, or you can not elect them during the next election meeting. Pretty simple. Okay, we mentioned you can't vote by proxy or secret ballot at board meetings except in the election of officers. You can use email as a means of communicating with other directors. You cannot vote on association issues via email. You can discuss, fact find, gather information, communicate as to, well, I think we should go in this direction. You just can't have the final vote be via email. Now, I say you can't. In reality, there are some ways maybe you can. And what I mean by that is there are two different things that the board can do. One is not voting via email, but potentially deciding via email. Okay. That would mean that either you're ratifying the decision after having a full discussion of the issue during the next board meeting. That should be used sparingly. It's basically for emergencies where you couldn't get your job done before you were able to hold a board meeting. That's ratification. The other one, unless your governing documents say you can't use it, Chapter 617 says that you can have a unanimous written consent, which is a resolution of the board that every director must sign, consenting and agreeing that everyone would have voted this way if there was a board meeting. Meaning, you know what, there's really no point in having a board meeting. And under the statute, under Chapter 617, the not-for-profit statute, this actually replaces the need for a board meeting altogether. Okay. No individual director should make any decisions for the association, sign contracts for the association, go out to someone's property and tell them they're in violation of the covenants on behalf of the association, or ask someone to do something for the association, unless that power has been delegated to that individual or it's a true emergency. Not, well, John really needs to mow his lawn. That's not a true emergency. Okay? It's got to be a real emergency to even remotely justify the president choosing to take matters into their own hands. Okay, the officers and directors have the fiduciary duty. We talked about that. The right to not be the right to not be right is called the reasonable business judgment rule. It's really called the business judgment rule. But that's the one where I said you're judged by kind of the reasonable person standard, where if you thought that this was in the best interest of the association, you're probably okay as a director. We talked about agendas for all board meetings, so we're good there. We talked about 48 hours notice posted in the community before any board meetings. You now need to have an agenda included with that notice. Except in an emergency. Again, a true emergency, not we want to move forward with this project. We must move forward with this project. Okay. And it's not a must because you want to. Meeting notices that will require 14 days. Again, a special assessment or an amendment regarding a rule regarding parcel use, whether the board adopts the amendment or the members adopt the amendment to the governing documents, it's going to be a 14-day notice for all of these. It can be posted on the association's website or app if you have one, in addition to any other authorized means of providing notices. That notice also needs to hyperlink on the association website to exactly where the meeting notice is posted. So if you send an email, it's not just a copy of the notice, it's including a hyperlink to what's on the website if you've got a website. Directors cannot be compensated in any way for what they're doing except for these specific items. You cannot accept kickbacks. You cannot accept a salary unless you are participating in the same financial benefit as everyone else in the community, meaning there's no real conflict. You're being reimbursed for actual out-of-pocket expenses that pertain to the operation or maintenance of the association. You're getting insurance proceeds that everyone else got. You're getting a fee or compensation authorized in the governing documents or by vote of a majority of all members voting in person or by proxy, or the developer or its representative can be compensated for its work. Now, again, no kickbacks allowed. The statute changed last year to say that if you accept kickbacks, meaning something that's worth something that you received in exchange for promoting a product or service or signing off for a product or service, that's not going to be allowed. Now, there are penalties for this. One is immediate removal from the board. The other is that you might end up with civil or monetary damages. So that you come off the board as soon as the board finds that this happened. Now, if an officer, director, or manager can continue to accept food to be consumed at a business meeting, meaning I can meet with the board or the manager and pay for less than $25 worth. So we're not going to Ruth's Chris. We might get away with the ale house per person, or a service or good received in connection with a trade fair or education program, which is why if you were at the condo and HOA expo this week and you took the little squishy balls or you took a pen or a pad from us, we're allowed to give those out to you, even though there's some value to them because it was part of a trade fair or educational program. So grounds for immediate removal from the board. You need to be removed, not the board gets to choose, but you are removed from the board. If you forge a ballot envelope or voting certificate used in the election, steal money or property of the association, destroy association records so that something is not found out that you did wrong, or obstruct justice under the Florida statutes. I think those should be pretty clear as things you should not be doing. Contracts between an association and a director, officer, manager, or someone else related to that person are a conflict of interest. So I'm not going to go through this in detail. We've got an entire class on conflicts that I recommend you check out, and I'm on slide 54 and it's 1125. So we're going to speed through some of this stuff, but just understand you've got to disclose every conflict of interest like what I described. You've got to give notice of the conflict 14 days before anyone's going to vote on the contract or the service. And you've got to have a supermajority of the directors vote in favor of it. 2/3 of the directors need to vote in favor of that contract. And the person that has the conflict cannot be present in the meeting after they present. So in other words, the motion can be made with that person present. They can present what their position is. But when the board is discussing and voting on it, that person abstains from voting and actually leaves the room. All right, so skipping the rest of conflicts, because again, I strongly suggest that you check out our conflicts of interest class. This is an important topic, and it's not one that in a 2.5-hour class with Q&A, we can really cover adequately. For these things, you are guilty until proven innocent. Just understand, if you're accused of this stuff and you are charged by information or indictment, not just the board thinks you did wrong, but that an actual criminal investigation results in a criminal charge, you are off the board. Now, if that criminal charge is dropped during your term, or there's a finding of not guilty during your term, you come right back on. If your term expires while that charge is still pending, you need to be reelected if you want to come back on the board, or appointed by someone else after the charge has been dropped. We talked about the excessive gifts. That person is pulled off and the vacancy is filled by appointment. If someone accepted these $25 gifts or $25+ food or other gifts, kickbacks, dollars, whatever. We talked about how vacancies are filled. Members get to participate at board meetings just like they could at member meetings. So again, this is one of the policies you should have. We already went through this for members. Member meetings, it's going to apply the exact same way for board meetings. Recording and handicap access. I talked about recording, but I do want to be clear. You have to allow for anyone who has a disability to attend at a location accessible to physically handicapped persons. So if you have to go upstairs and there's no ramp, and that person is in a wheelchair or is otherwise disabled in a manner that requires them to use a ramp, that's just one example, but you have to give them the opportunity to attend just like anyone else would at that board meeting or member meeting. So just understand you might need to provide those accommodations. You might need to modify your property, even if it isn't required by the Florida Building Code, to allow that person the same use. Any expense that's incurred in making that change is probably something the member will need to pay for, the resident will need to pay for, not the association. But if that comes up, especially if you haven't already adopted the fair housing policy that I strongly suggest every community association in Florida have, you need to run that by counsel. When you screw those up, you get into a lot of trouble. And when I say trouble, I mean financially. And you end up paying out big, big money to your lawyers and to the owner. And even if you win and you don't have to pay the owner, you're generally not going to be entitled or able to recover your attorney's fees. So even if you spend $40,000, $50,000 being defended, that's not money you'll get back. So don't mess around when it comes to these fair housing issues, disability related requests. The association can create committees. There are two types: board committees, which is has to be basically people on the committee or directors, unless the committee is created by the board or otherwise authorized by the articles, or the committee relates to the election, nomination, qualification, or credentials of directors, meaning you don't want the directors on the board, the committee that decides who the directors can be. Then you have advisory committees. Now, those aren't really a big deal. The only time that you'll generally have to provide notice of their meetings for the advisory committees is when you're having a decision to approve or reject an architectural application, or if it's the board is being told whether to spend money or not. The architectural committee is generally going to be the biggest one. And then you'll also have, if you intend to use fines or suspensions, basically a compliance committee, but it's really the fining committee that is also going to be required if you want to use fines. Let's see. If you're on here, you're probably not a developer appointed director, so we'll go through this very quickly. You basically need to disclose that you have an interest in the developer's business, or that you were appointed by the developer, that you have to disclose once a year if that is your position. If you're a member elected or member appointed director, you don't have to give this disclosure. Okay, are we having a board meeting or not? First things first, sunshine law does not apply to a community association, period. So if someone says you're in violation of sunshine law and you're an HOA, you can tell them they're an idiot. In reality, there is a law that's similar that applies, but sunshine law applies to government meetings. By the way, so does Robert's Rules of Order. Okay, that doesn't really apply to HOA meetings. If you've got Robert's Rules in your bylaws, take it out. But a meeting of the board is anytime a quorum of directors is together conducting association business. When I say together, that can be over the phone, it can be over Zoom, it can be anywhere. Okay. What is not clear, in my opinion, and I know that not all attorneys will agree with this, but, and when I say all attorneys, I mean including within my firm, my opinion is you're not holding a board meeting if you're only gathering information and you've explicitly decided that no decisions will be made during this meeting, even though a quorum of directors is present, because in my opinion, you are not at that point conducting association business. You are conducting an information gathering session on behalf of the association. Conducting business is making decisions, in my opinion. You're going to want an opinion on that issue from your attorney. Do not rely on anything that we say today as legal advice. So you're going to want everything we say in writing from your counsel. Now, I'm clarifying on this point because I've had several people come up to me and say, I don't know what I'm talking about. But they haven't been able to point to one single case that says that conducting business means anything other than my interpretation. So, most of these things that I've said today, they're just the law. This one is my interpretation of the law. All right, moving forward. How to get off the board, get recalled. Someone decides that someone else could do a better job and they want you off, they pull you off. You don't get the certification from today's meeting or the signed piece of crap. You have a criminal charge, a felony theft or embezzlement offense involving association funds or money. You get the excessive gift. You resign on purpose in writing. You become more than 90 days delinquent in the payment of any monetary obligation to the association. I vaguely mentioned this earlier, but I want you to understand. If you are on the board of an HOA in Florida and you are more than 90 days delinquent, you're not on the board anymore. Florida statute says you are considered to have abandoned your seat on the board. The other way you can get off the board is, hopefully, if you pass away, you will no longer be serving on the board. I see things joking about ghost jobs, and I really hope that's not one of them. A few things that you should know about, which we don't have time to go through, but again, any of this, you've got my email address. You'll have it in the slides. You've got it on the top of my picture on your screen right now. Please genuinely feel welcome to email me if you have any questions following today's presentation. I would request that you don't do that until after the Q&A is over, because I routinely receive requests right in the middle of a webinar, and that doesn't really help you because I'm not answering them in the middle of a webinar. I'm paying attention to you guys that are listening to me. So again, the minutes should be taken at every board meeting, every member meeting, and every committee meeting where notice was required. They are not verbatim records. They say well, I don't need to reiterate. I already talked about it. But keep in mind, you're going to record how every single person voted. The easy way to do it is if everyone voted the same way, you just say it was unanimous instead of recording each person's individual vote. So if it was, all voted in favor, that's the way that you can record it rather than having each vote. All voted in favor, John abstained due to expressed conflict. All right, right of access to parcels. Unlike a condo, you do not have the automatic right to enter onto someone's property and resolve an issue. If you have the right to perform self-help, that's why we have the little lawnmower image here, then you do have that right to enter onto the property. You might need to give notice to the owner in advance or the resident in advance of stepping onto that property. It may not be the best idea to step onto that property because we're in Florida and people shoot at you when you step onto their property. So, we'll get into the case law about that issue later. I'd suggest checking out, we have a really good covenant enforcement or covenant violation class that I'd suggest reviewing if you want more information on this particular topic and why I think fines are a complete waste of time. Moving on, material alterations, unless your governing documents say so, changing the visual aspect of the property is not something that requires a member vote. What you might have in your governing documents is you need to have a vote for those material alterations. It might say you need a vote to spend more than $5,000 of association funds or something like that. That might be the replacement vote that you still have to get. By the way, if it says $5,000, you need to up that to 20 because anytime you need to do any repairs to the clubhouse, it's going to cost more than $5,000, regardless of whether it's a material alteration or not. All right, moving on. Amending your documents, we talked about a little bit. There are a couple amendments I think everyone should be doing if it's not already in your governing documents. One is more appropriate for the covenant enforcement class, but I think it's important enough to mention. You want to have it where the association actually recovers the fees and costs incurred going after an owner for violating the covenants. So have an amendment, if your governing documents don't already say it, that does two things. One, it says that the fees and costs are recoverable just like in the collection process, regardless of whether you file a lawsuit or not. Most declarations say you get it back at the end of a lawsuit. Okay, well, what if the owner cures after you've spent $3,000 battling it out, but before you filed that lawsuit? You're not getting your money back. So change that part. Number two, make it an assessment against the individual lot. That means that if the owner doesn't pay it, rather than the association being out of luck, the association will end up with the property or having a third party pay it and get the problem child out of the community. Now, it may be that someone made a mistake. Great. They made a mistake. They're willing to fix it. Reach a settlement with them where they get to pay over time instead of having to pay it all up front as an assessment. But don't just let it go. And don't choose not to do the enforcement solely because you don't want to spend the money and you don't think you'll get it back. Okay, moving on. You do have to send copies of any amendments. If you don't think you can get the vote, you have to send copies of any amendments after the amendment has been adopted. The members generally will get to vote on almost all of those amendments to the declaration, bylaws, and articles. Your bylaws and articles might say that the board gets to decide these issues. At that point, you're going to want to put it on the agenda for a board meeting, give at least 14 days notice anyway, and still send everything out after the board votes. If you don't think you can get the vote, I mentioned earlier, amend the amendment provisions, then try and deal with the substantive issues that you're trying to amend the governing documents to accomplish. And electronic voting can help with that a lot as well. Leasing restrictions. There were recent changes in 2021, I think, that generally speaking in the past, it was if you're adding a leasing restriction that didn't exist before, only the people that actually voted in favor of that restriction or bought into your community after it went into effect were actually subject to the restriction. So you had to figure out which lots had to comply and which ones didn't on a case-by-case basis. There is a new, as of 2021, a new restriction where the statute actually allows you to adopt an amendment that says that if the rental is for a term of less than 6 months, or more than 3 times in a calendar year, that'll apply to all the owners. The reason for that is because short-term rentals have become so prevalent that it was never anticipated, and frankly, couldn't have been really anticipated by the people preparing these governing documents 30, 40, 50 years ago. So now, generally speaking, those will apply to everyone across the board in your community, those short-term rental restrictions, if they comply with what's in the statute. So when you're creating those, make sure that you're doing what's in the statute and not just what you would want it to be. Because there are distinctions between a short-term rental restriction and what's in the statute. Okay, moving on. Some of this we will have to skip just because it's now 11:40 and I've got over 100 slides left. So just understand, I'm trying to make sure that you guys get time for Q&A. Oh yeah, we've only got 20 minutes. Okay. So the association can make rules and regulations. I talked about this. They need to actually be enforceable. And what I mean by that is it needs to be something that's supported by the declaration or bylaws and that doesn't conflict with any of the governing documents. The board doesn't get to decide that you're going to ignore the governing documents and tell people they're going to have to do things or not be allowed to do things, that those recorded documents that the owners subjected themselves to by buying into this community don't allow for. So you got to be reasonable, not only in the way that you create the rules and what they are substantively, but also in the way that you enforce them. You don't want to enforce them in a way that is picking and choosing. So again, covenant enforcement process should be outlined in your policy governing covenant enforcement. And it should say that you apply everything uniformly across the board. You're going to be uniform, consistent, and you're going to do it within a timely manner. You're not just going to let things sit for 2 years and then decide, maybe we should do something about this. Okay, moving along. When you're adopting rules, we talked about a 14-day notice that goes out to the members, etc. The Marketable Record Title Act is an important thing for your association to know about. You've got a legal obligation at the first meeting of your board that occurs after the election meeting. And I don't mean the organizational meeting. The statute says it's the first actual board meeting after the org meeting. And that org meeting is when you decide who the officers are, basically. At the next meeting, you need to mention this Marketable Record Title Act and preferably decide on the date when you're going to record a document preserving the association covenants. This is a law that basically says that if 30 years after what's called a root of title, we'll get into what that means in a minute, but 30 years after that recorded instrument is recorded, the covenants pertaining to that particular property will expire unless they're preserved. If they expire, you need to go through what's called a revitalization process. That can be $5,000 to $10,000 more expensive than recording what is now just a couple pages outlining the documents that you want to keep in place going forward. So your covenants are the things that require people to do things on their property, pay assessments, not paint their house pink with purple polka dots, mow their lawn, maintain their property, things of that nature. Those expire 30 days from a root of, 30 years from a root of title unless they're preserved sooner. Now, the root of title, the easy way to look at this is make sure that that preservation document is recorded no later than 30 years after the original declaration was recorded. And then 30 years after that preservation, you need the next one, and so on and so on and so on. In reality, the root of title is most likely going to be the actual deed transferring ownership to each property owner in the community from the developer. The problem with that is that to analyze it, you have to take a look at each property in the community to decide what that 30-year date is. It's easier to go with the declaration because we know that that's earlier because the transfer couldn't have happened from the developer until there was a developer who created a declaration and developed the community. So most attorneys will tell you that it's actually the date of the declaration. It's 30 years after that date. That's how we calculate it in-house. If a client comes in and says, I think this is already expired, what do I do? Then we might get into the analysis. But for, I'll call it safety purposes of not having to spend that 10 grand or so, whatever the cost might be to revitalize the governing documents or revitalize the covenants more accurately, because the documents don't expire, the covenants do. But you're going to want to just make sure that you're at least tracking that 30-year mark from when the declaration was recorded to make it easier to track instead of a lot by lot analysis. Okay, we talked about this. You got to let process servers into your community when they try to get in. You can't just say, well, we're a gated community, stay the heck out. Doesn't work that way. You have to allow people to serve a lawsuit in your community. They might need to prove that they're a process server and that they're licensed, etc., but you need to let them in. If you are using a property manager and they're being paid and the association or associations served contain more than 10 units or have an annual budget in excess of $100,000, that manager needs to be licensed by the state of Florida to be a licensed community association manager. If their work is purely ministerial, they're just mailing things or making copies, things like that, and they're under the direct supervision of a licensed CAM, that individual doesn't need to be licensed. So a lot of times that's your assistant manager. That person might not need to be licensed, but you're going to want to run that by, frankly, your attorney who doesn't represent the management firm. There are management standards in place. We can discuss that if you really need to. Most of the management firms that operate on a regular basis in the state of Florida are doing so properly, even if it's not the way that the individual communities might prefer. Construction defects. So I won't go into detail about this, but there was a change last year. Understand that you've got 7 years from the date a certificate of occupancy was issued for any building in your community or your community as a whole to raise a construction defect claim against the developer. So you are really limited because it may take 5 years for them to turn over control. And within the 2 years that you then have left to file that lawsuit, you got to get an engineer out to the property, send the developer notice before you go through the process of filing that lawsuit. And that process could take 6 months in and of itself, leaving only a year and a half to negotiate and file a lawsuit. Could leave you with less time because the developer technically has up to 7 years to develop the community. I've seen some go longer. Okay, so you want to be careful. The second that you get that turnover done and the majority of the members have taken control of this community, you'll want to get an engineer out to look at everything in the community and make sure there aren't defects that you need to be dealing with, rather than the individual members needing to pay to fix a problem created by your developer initially. Emergency powers is a great one to skip through, although hurricane season is coming. Hopefully it'll be a light one. That's not what we're hearing. But in the event of a state of emergency declared by your local municipality, meaning your city, your county, or by the state or on a federal national level, once that state of emergency is declared, these powers in the statute that we mentioned here will kick in and they will stay in effect until every state of emergency declared for your local region, and that nationwide, statewide, whatever it is, all of those have been shut down. So during that state of emergency, you are able to use all of these powers to protect the association from damage, the possibility of damage due to the state of emergency, or thanks to COVID, the possibility of injury to people due to the state of emergency. I won't go through what these powers are, but they are numerous. They include levying special assessments to deal with damage, but it's primarily intended to protect your community in the event of basically a potential catastrophe. So moving on from the emergency powers, and yes, we're going to skip a few slides here because if you have an emergency, hopefully you're using an attorney who's still going to be accessible and reachable through your cell phone. The one thing I will discuss is what you should have in a state of an emergency. Make sure you got pens and pads, that you've got external battery chargers so that you can charge your cell, your computer, etc. And make sure you've got a way of getting on the internet that isn't just your cell phone or just your house. Make sure you've got at least 2 ways to access the internet. Because if cell service shuts down because a bunch of towers go down because of a hurricane, you want to know that you still have a way of getting information that isn't, preferably you'll also have a radio. But if you don't, because many people now don't, just understand you're going to want to have a way of communicating with your co-directors so that you guys can protect your association. Now, you may also be the type that gets the heck out of Dodge. Great. But you're going to want to be able to find out what happened to your property, even if you don't care what happened to the community. So those external chargers are something I somehow haven't heard many attorneys suggesting that get included in the board's respective emergency kits. I think every director of an association should have the equivalent of a bug out bag, but it's primarily to protect the association and just stays in a closet until it's needed. Anyway, driver's licenses. When people come to your gate, you need to give them the ability to not have to swipe their driver's license. You can't force them to swipe. You can't keep the information kept from that swipe. What you can do is take a photocopy of their ID if you need to, or collect the information as to what's on there yourself. You just can't digitally collect it from that swipe, the stripe that's on the back of the driver's license. Okay, budgets. The most important thing about budgeting is it is an estimate, and it needs to be an accurate estimate to the best of the board's ability. You don't have the legal authority to underfund your budget. It is your fiduciary responsibility as a director to make sure that that budget will actually accommodate everything it's really going to take in your estimation to maintain and operate your community the right way as to what's required by Florida law and your governing documents over the course of the next year. If the members want to reduce the assessments so that they don't have to pay as much and they're not actually properly maintaining the community, let them propose an alternative budget, which is their prerogative to do. But you as a director are proposing a budget that really meets the needs of the association. I don't want to see you levying special assessments 3 months after you adopt the budget because you knew you were underfunding. I don't want you not spending money towards the end of the year because you're afraid that you're going to be over budget. Other than not having the funds physically available, you do whatever is necessary to properly operate and maintain your community. You don't back into the budget. You don't water down the budget. You let the members decide that they don't want the budget that you've created, but you make sure you're complying with your fiduciary duty. There are a lot of people on fixed incomes in Florida. I get that. There are a lot of people that don't want to pay more in assessments. I get that too. But you are running a corporation. You are running a business, whether you believe it or not, and you are legally obligated to make sure that that business has the ability to run properly and in compliance with the documents that govern the community and govern your actions. So if you don't want to pay more in assessments, move. If it takes more to properly operate and maintain the community, put it into the budget and take care of it. And when people don't pay their assessments, collect them. Don't let it accrue until it's $5,000, $7,000, $10,000 before you actually send out a notice of late assessment and try and collect the assessments. That's another class that I'd suggest everyone check out. If you don't understand the collection and foreclosure process, mortgage foreclosure, bankruptcy, that's another class that we do have on our website. All of our past recorded classes are available at kbrlegal.com under the resources tab. So you might want to check some of those out when I say we don't have time to cover this issue. But moving along. So you need to give notice of that the budget's going to be adopted. Non-emergency special assessments require 14 days notice. The notice of the budget meeting must be posted conspicuously on community property at least 48 hours prior to the meeting. If the governing documents don't say that you have to give a longer, better notice. You do need to say that an assessment can't be levied. I want you guys to know at a board meeting unless notice of the meeting includes a statement that assessments will be considered and the nature of the assessment. Now, if it's your budget, then the nature of the assessment are the line items on your budget. If it's any other assessment, like a special assessment, you need to be really clear about what that money is going to go towards. So moving along, after the budget's adopted, the association needs to provide each member either a copy of the budget or a written notice, and that can be on a postcard, or if they're accepting notices via email, that a copy of the budget is available to the members at no charge and will be provided within 10 business days after receipt of the request. So basically, this is a records inspection request. It's just one you don't get the charge for responding to. Okay, we're going to skip a lot of this because we've got about 10 to 15 minutes before we really need to get into the Q&A so that I can answer your questions here. But use last year's actual expenses to plan for next year's budget. You might want to use last year's expenses plus inflation. You might want to go out every 3 to 5 years, even though it's not required by statute in an HOA, to have a reserve study done or have an investigation of what you're really going to have to spend to fix the clubhouse, to fix this, to fix that, even if you don't have reserves. That's going to give you a more accurate depiction of what you actually need to properly operate and maintain your community over the next year versus just applying for inflation and saying, well, we think inflation was 9% this year, so we're going to increase our budget by 9% next year. It doesn't always work that way. Monies that are in the operating section of the budget aren't restricted to a particular use. So just because you've got line items, unless they're actual established reserves in your community that either the developer created, the documents created, or the members voted on, and a majority of the entire membership voted to say we want a reserve for the roads, the clubhouse, whatever it may be. If you don't have that reserve, any line item on your budget that's an operating expense, those funds can be used for whatever the heck you need throughout the course of the year. So don't think that while we budgeted X for legal, hopefully you're working with someone who's going to try and use less money than that. But if you need more money than what you budgeted for legal, you can say, well, we're going to take money from what we planned on landscaping because that was just preventative maintenance that doesn't really need to be done. We were planning on replacing those trees next year anyway, whatever it may be, those bushes. All right, but bottom line, you can use operating funds for whatever they're needed for. Just because you have something in your budget doesn't mean you need to stick to it, or frankly, even should stick to that budgeted line item, dollar for dollar, penny for penny. Okay, your budget should say what you're bringing in and what you're sending out. It should include operating funds, and if you have any reserves, it should be included. It should say what the common operating expense is. Keep in mind, what you're looking at is income from assessments and other things, and expenses. Whatever you end up with is the assessment. So whatever your budget calls for, that you plan to spend, should be divided by the number of lots in your community to come up with your assessment, your maintenance assessment. A lot of people don't understand that that's not just some arbitrary number the board came up with, other than the fact that the board arbitrarily decided what goes into the budget and what doesn't. That assessment number should be coming directly from your budget divided by the number of lots in the community. It should be very easy to calculate. Moving forward, we're not going to go through a lot of this. Most communities in an HOA don't have reserves, so that's something I think we can skip. If your community does have reserves and you're confused about how those work, using pooled versus regular, waiving, partially funding, terminating reserves, again, email me at as@kbrlegal.com or give me a call. I genuinely am happy to help with these issues. We just don't have 5 to 8 hours to go through everything that's in here. And I've already skipped a lot of what I would like to say about some of the topics we've already covered. So special assessments, we already talked about. Financial reports, just understand there are different reports and reporting levels that are required for different types of communities based on the dollars of income that your community is going to have. The members are entitled to a copy of that financial report 21 days after it's completed or received from a third party. You cannot wait more than 120 days after the end of the fiscal year to produce that to the members. It needs to go out to them. So just understand your financials are something that you should have a plan for in advance of the end of your fiscal year. You're not just saying, well, maybe we should do something about this now that the year's over. Okay, I talked about the different levels of financial reporting. I call this the Mo Money, Mo Problems deal. But it's basically, if you are bringing in and generating more money, then obviously there's a higher level of scrutiny that's going to be applied statutorily to the finances and the documents that create your community. Now, the thing to keep in mind is that the association does have the ability to change the level, of reporting each one of these items. You can reduce the level, you can increase the level. That change is only going to apply if it's approved by a majority of the voting interest present at a duly called member meeting, not a board meeting. The board doesn't get to decide, no, we just don't feel like having an audit this year. It's too expensive and we don't need it. The members decide that. So again, we talked about the board decides most things. This one's a member vote. Now the board can decide to raise the level and say, we don't really trust the records from the board that we took over for. We're going to go ahead and have an audit instead of just a minor inspection. Okay. If there are no reserves, you do have to disclose basically that a special assessment is likely in your financial reports. If there's something that you have to maintain as an association that might fail in the coming year. There are government filings to be aware of. Hopefully your manager or CPA is giving you guidance about these things, but understand you do need to file an annual report with the Florida Division of Corporations. Your income tax is not something we would be able to help you with, but when it comes to the Division of Corporations, we do file these on behalf of clients who ask for it. Contracts and bids. Contracts need to be in writing if it can't be performed within a year, or if it's for services. This is the statute of frauds in Florida. In other words, we want to make sure that it's clear what the contract actually called for. Really, there are certain terms that should go into every association contract. One of the biggest problems I see communities getting themselves into is that they don't have their attorney review every single contract. My opinion, and it's a strong one, is that every contract from your landscaper to the $500,000 repair to your clubhouse or the $1 million resurfacing of your roads, whatever it is, it's something that should be reviewed by your attorney. Most contracts that you're going to get from a vendor, I don't care who it is, I don't care what vendor it is or how good they are, the contract is one-sided, period. Because they're expecting you to come back and say, well, what about this, 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 and this? They're going to make it one-sided if they get to draft it. Give your attorney the opportunity to protect you from having no fee provision. In other words, you can't recover your attorney's fees and costs, even if you win a lawsuit against the vendor. To having where the vendor is able to get out of trouble and the association has to defend the vendor for anything the vendor does wrong pertaining to the contract. It's things of that nature that the board needs to be aware of and is not going to know to put into this contract. And frankly, from a legal perspective, may not be legally authorized under the Florida bar rules to practice law without a license. Give your attorney the opportunity to protect the association, which is your lawyer's job. So again, every contract should be reviewed by an attorney, in my opinion, and probably drastically revised by an attorney. A written estimate is a binding agreement, but is a very unclear binding agreement once you sign it. So understand, when all you've got to perform work on your property is a written estimate, you've got zero protection whatsoever other than to say the specific things that are put here, which are always going to be vague in an estimate, isn't what you did. But there's no fee provision. There's no recovery of anything. It's a mess. So again, I know I've harped on it for a couple minutes now. Make sure your attorney reviews every contract, every estimate that you're going to sign off on that you're going to use in place of a contract so that they can protect you. I've seen people say they didn't want to pay $3,000 for an attorney to review a $500,000 project contract. That's ridiculous to me. You're talking about $500,000 that you're guaranteeing you're going to spend, plus whatever change orders come into that contract, plus whatever damages might result if the vendor screws it up, and you haven't had an attorney review the contract. Doesn't make sense to me. So off my soapbox real quick, you do need to get bids if the contract you're talking about is going to be more than 10% of the total annual budget, including reserves. You don't need to accept the lowest bid. And frankly, I make this comment all the time. If you're talking about a professional, I don't want the cheapest brain surgeon. I want the one that's going to do the best job for me. Now, the good thing about professionals, you don't have to get bids from professionals. So you don't need it for employees. You don't need it for contracts of an attorney, accountants, architects, community association managers, engineers, and landscape architects. That doesn't mean you're not going to get it anyway. I have a lot of people say, we want to get 3 bids from attorneys. I don't think that makes sense to me. You might want to interview 3 attorneys, but if you're basing it on a bid, where you're basing it on what's in the retainer agreement and not the services that are going to be provided, same thing with a property manager, you're basing it on what's in the contract only and not really meeting with the person, I think you're missing out on a lot of good opportunities. But anyway, if the vendor is the only provider in the county, you don't have to get bids. So in other words, if there's no one else to put in a bid other than someone that would have to drive from Tallahassee to Miami to service this community, I don't have to get another bid. Okay, we went through this. Let's see. Not going to go through more bidding. Okay, you can have bulk contracts for communication services. We're talking about internet and cable here. Those are subject to certain requirements. They can be canceled by the members if the members vote to get rid of the contract at the next board meeting after the contract is signed. That is not an at any time type of situation. So if the members don't choose to have a meeting and vote on this issue and have an affirmative vote of a majority of the members present, then you don't cancel the contract. If that contract is canceled that way, the association really only pays what was incurred by the vendor up through the date of termination. That gets terminated also, regardless of what the termination provision of the contract said, whether it was 90 days, 120 days, 60 days, it gets terminated immediately as of the date that the association provides the notice. And the termination is what cuts off the liability dollars-wise for the work being performed. You might not be able to terminate immediately because you may need to get in a new vendor, but just understand this is what the association is able to do regardless of what's in the contract. Okay. We talked about suspensions. I strongly suggest that if you're interested in using this, it is a very helpful tool. Check out our covenant enforcement webinar. We just don't have the time to go through it right now. Fines, same thing. Check out covenant enforcement. Talked about suspensions. Covenant enforceability and self-help. Self-help is one that I will talk about. Okay, you've got some restrictions that you can and can't enforce. You can't have a discriminatory restriction, which is what I talked about earlier. You know, no Jews are allowed in our community. Sorry, but you can't enforce that. One thing I want to talk about is the $100,000 rule. Okay, this says that if a suit is being brought by the association, not by another party, but by the association, that involves more than $100,000 in damages, this is usually going to be an action against your developer or a major lawsuit. You need a vote of a majority of the members voting on the issue in order to approve that litigation. Now, if you file beforehand, basically you just get the vote afterwards and the case gets put on hold until you're able to get that vote. Now, this is intended as a shield to the members, not a sword for the other side to use to say, nope, you can't do this. You can't sue me. I'm not responsible because you didn't get the required member vote. It's intended to protect the members from lawsuits that shouldn't be filed. So you just go out and you get the vote after the fact. The case gets put on hold from the time that this issue is raised up to the time you actually get the vote. Moving forward, disputes between an association and owner, you're going to want to mediate those disputes and try and settle them out. If you have to go right to court, there are procedures that you can follow, but most of the time, covenant enforcement disputes and certain other disputes that are listed here, that's going to be a subject to pre-suit mediation, where the association sends a letter that says you have 20 days to choose one of the 5 mediators listed below and actually sit in a room with us and try and resolve this dispute before we're going to file our lawsuit against you for covenant enforcement or whatever the issue may be. There are certain things that require that, certain things that don't, but you'll just want to run through, with your attorney, do we need to go through pre-suit mediation, or is this something where that's not even a relevant procedure for this type of dispute? It's going to be relevant for all covenant enforcement, which is why we put it here. Prevailing party attorney's fees, again, you only get your fees and costs back if it's authorized by contract or statute. That's why I say with certain vendors, if all you have is that estimate that you actually signed off and said, yep, I'll stick with it, there's no attorney's fee entitlement there, even if they screw up and you win a lawsuit. So you're putting yourself in a position where even if they screw up, there's really no risk to the vendor, because what are you going to do? Spend $10, $20, $30,000 suing me on a $5,000 project? Good luck. So moving forward, we talk about self-help versus an injunction. And as I kind of blitz through the slides themselves, I'll explain what this means. Self-help is going onto someone's property and curing a violation for them. Basically saying, I'm going to enter onto your lot. I'm going to mow your lawn because you haven't mown your lawn in 6 months and it looks like crap. So I'm going to go ahead and do that for you instead of going through this elongated covenant enforcement lawsuit process and trying to get an injunction against you or wasting my time finding you without curing the violation. I'm going to go on your property and cure it. Okay. If the association has that ability in the governing documents, the association must use that remedy, or at least attempt to use that remedy, before trying to get a lawsuit filed and go after an injunction. So there's Florida case law, these two cases, the Meconico case and the one that came before Mariello. And they basically say, you can't just say, I'm afraid I'm going to get shot, I'm not going onto someone's property, if you've got the right to do that. It's too speculative, according to the Meconico case, to say, I don't think that it's fair for me to have to go onto someone's property and cure the violation. If you're not willing to go onto that property and cure the violation, you are smart. However, the way to do it properly is remove that from your declaration. Have an amendment prepared by your counsel that removes that. Leave a carve out for whatever maintenance you will do. If you're willing to go spray the lawn or, pardon me, spray the driveway and get rid of those weeds, great. If you're willing to get have someone mow the lawn, edge the property, great. But if you're not willing to go on the roof and fix the roof because it's been damaged, which is something you might have to do if you've got that ability under the governing documents under these two cases, then what you're going to want to do is make sure that you pull that out of the declaration and leave a carve out for the things that you are willing to do. And this is an amendment. I think we've got 5 or 6 of them pending just in my office, not firm wide, but just in Orlando. Okay, moving forward, assessments and foreclosures. This is another thing I strongly recommend. You have a policy automating the process. The board doesn't vote. The board doesn't decide. If you don't pay, the association's coming after its money, because if the association doesn't do that, then all of the other members are covering your butt until you pay, and you won't pay until the association goes after it. Now, we have a collection class, so I'm going to skip through a lot of this as well. But the bottom line is everything you do in this collection process, in my opinion, should be geared toward either settling with the owner and having a written payment plan with actual consequences of a default, or foreclosing that property and taking ownership. Okay. You should not be allowing the owners to simply not pay. Some of this talks about mortgage foreclosures. Unfortunately, we don't have time. Just understand also that any of the classes that I'm mentioning are things we do offer to our clients individually, and you'll just pay the time and you'll have an indefinite Q&A, but you'll just pay for the time that we spend going through these issues within that seminar that I'll teach directly to your community, your board. So just understand that is an option. If you don't want to attend another board certification class, or you want to get all of the information, I'll sit with you for an entire day and go through this presentation again and go through everything you guys missed. So yes, we are skipping a lot of this, but you do have the opportunity, if you're working with our firm, to get one of the attorneys that you're working with to teach you all of this material. All right, insurance, make sure you have it. Make sure you are covering casualties, damages, and directors and officers liability policies. We talked about some of this, transfer fees and estoppel certificates. Watch our collection class if you want that covered, but it's basically a document that says here's what's due. That needs to be provided within 10 business days after it's requested. And it says, hey, I understand you're closing on a sale or refinance of this property. If you want to start fresh after that sale or refinance, here's what you need to do. Here are the violations that need to be cured. Here are the assessments that need to be paid, etc. So there's content that's statutorily prescribed, and you're basically going to want to include anything that they ask for. If what they ask for is not in the form provided by the statute, you might not have to provide it. So you'll want to run that by your attorney. Let's see, skipping through the rest of this. You know what, candidly, I know what else is in here. It's all stuff that we have other classes on. Fair housing is, we have the animals and service animals, the FFHA class. I would recommend watching that one. Again, if you've got specific questions that we don't get to in the next 15 minutes or so as part of the Q&A, do feel welcome to reach out, because I know we didn't get to cover everything. And recall, the one thing I want you guys to know about recall, if you get a recall petition, send it to your attorney that day. You only have 5 business days to decide whether or not you're going to allow the recall, meaning to remove the director or directors that the recall petition says you have to remove. So the biggest thing that you need to know is that this is a big deal. It is urgent. I've had recalls in larger communities where, keep in mind, we have to review every recall ballot to see if it's legally valid or not. And in a 3,000 lot community, that means you have to have a majority of the members voting on the recall. So that means in a 3,000 lot community, we were reviewing at least 1,501 ballots. Okay, that takes a lot of time. Sometimes it'll take 2 attorneys an entire day or 2 to review all that material. So make sure to get this over to your attorney the second that you get it. Now, the turnover, again, the most important part of turnover from the association perspective, make sure you get all the documents the association's entitled to, all the information the association's entitled to, and make sure you have an engineer go out and check to make sure that the community is actually in the shape that the developer's engineering report and turnover reports say it's in. Candidly, do not trust what is in the developer's turnover report, because it's prepared by someone who has a relationship with the developer. Whether that person is trustworthy as a whole or not is irrelevant in my perspective. I want my clients to have the peace of mind to know that their own selected engineer did the inspection and believes what is in that report. Okay, I think this is probably it. Yep, so again, I apologize. I know we had to blitz through some of this information, but I wanted to make sure that we had some time for Q&A. And where I just answered, you might have heard me typing. I was not doing other work. I was actually answering a bunch of the questions in writing. So I don't know if you know, I believe if the members check out the answered portion of that Q&A section, you'll see the answers that we've typed. So if you asked a question that isn't being answered right now, check out that answered portion and you'll have, what we answered already. All right. So let's see. All right. So Jeff, the chat that you just added, is that the questions that I'm answering? Just want to make sure we're
Yeah. I just sent you the ones that you did not put into the written section.
Okay. Perfect. So Sydney asked, for annual meetings, 720 says at least 14 days notice. Does that mean mailing or received by the owner 14 days in advance? It's deemed received upon mailing. So what I mean for that purpose is, what we're talking about is you need to mail it out, email it out, send it however you're sending it at least 14 days before the meeting. When the owner receives it is not the association's problem. Gemma asks, on a 24-unit community, what should be the right vote approximately? Check your bylaws is unfortunately the best answer I can give. It's whatever the quorum is that's stated in your bylaws. The right vote, I don't know what that means. I'm presuming it's a majority of a quorum that you're looking at. So you just need to figure out from your bylaws, what is your quorum at member meetings, and from there decide what is a majority of that number. Alan asks, are proxies by board members allowed at board meetings? The answer is nope. Ed Parks asks, slide 50 parcel use, what does it mean with regard to requirement for 14 days notice? Just like certain other meetings, and Jeff, you can add the next batch. There you go. Just like certain other meetings, the association is required to give 14 days notice to the members of a board meeting that's being held for the purpose of adopting new restrictions or changes to the rules and regulations of the association. So that's what that means. Richard asks, HOA Townhome Board wants to change the color scheme. Why does this keep moving? The documents don't say anything about this. Okay, does this require a membership vote, or can the board vote to change vote for new colors? Material alterations is what you're talking about, and unless the governing documents specifically say that you need a member vote, you do not. So in the instance where the documents are silent, like you said, Richard, the members don't get to vote on that, the board does.
And Alan, as the reason it moves, as attendees leave, it affects the size on that right column, so it's going to mess everything up on there. So that's unavoidable, unfortunately.
Well, I will try and get through the last few, and I don't know if we have another batch coming in, but
Just a few more. I'll do that now, and this last batch, that's all of them.
all right. So let me get back to where we were. Arthur asks, is the 14-day agenda rule for HOAs, clubs, or both? A club is generally not going to be subject to 720 because it's a commercial entity. So unless it's somehow subject to Chapter 720 of the Florida statutes, that's not something that's required for the club to accomplish. Let me get back. Are veterans exempt from HOA assessments? No, Laura, they're not. Everyone that's a member of an HOA pays the assessment. Gary asks, is that 5 business days? I presume we're talking about the recall where you have 5 business days to get back to the members and actually have the meeting for the recall petition to be decided upon by the board. So the short answer is yes, that's 5 business days. Alexandra asks, hope all's well with you, by the way. Can a special meeting be extended to collect more votes after the ballots were counted? The result has been called. No and yes voting was announced, and although there was a quorum. No, you can't reopen the voting after the voting is done. You need to close the voting and then count the ballots, and that's it. Joe asks, what do you do if your association refuses to update the documents? You stick with the ones you've got, unfortunately, or you try different avenues to get people interested enough to actually amend. If you're talking about being a member and your board is refusing to propose an amendment to the governing documents, your governing documents probably provide a method for the members to propose these amendments instead of all of the board proposing it. Marilyn says, Alan, I just want to thank you. You're one of the best speakers I've listened to in a long time and kept all interesting. Thank you. That's a great one to end on. So again, thank you everyone that stuck around. I really appreciate it. I know we're about 4 minutes short. I'm going to leave most of that time for Jeff, but thank you all for attending. I hope you got something out of it. And again, I genuinely mean, if you've got any questions that we didn't answer today or that were in any way unclear, feel free to shoot me an email or give me a call anytime. So again, Jeff, thank you. Appreciate your help as always.